everyone, and welcome back to season 3 of Commerce Meets Law, a podcast we talk about various commercial topics and how they interact with the legal profession. Today's conversation is with a guest that I am so thrilled to have the chance to speak to on Commerce Meets Law. Our guest for this episode is Anna Yard, a barrister specializing in children law at Harcourt Chambers. In addition to her public and private children law work, Anna's practice also includes deprivation of liberty and forced marriage applications, all of which we get into during this episode. Anna is one of the Legal 500's leading juniors for 2025 within the area of children law, and she's also been recognized as one of the top legal LinkedIn influencers by TBD Marketing for 2024. In this episode, we discuss what drew Anna to family law as a practice area and why she decided to focus on the law of children in particular. We also dive into how she works on both private and public children law cases and how they differ from each other in terms of what's involved in the cases and also her approach. We also explore the current problems faced by clients and barristers in the family law courts and how the media influences this landscape in both a positive and a negative way. And finally, we discuss why barristers should have a social media presence and how they can do so in a sustainable way. Just a quick request before we get into the conversation. I'd really appreciate if you kindly give the podcast a follow and a rating on Spotify. The higher the better, but I leave the rating up to you as it really helps Commerce Meets Law reach more listeners. Without further ado, I really hope you enjoy this episode and I'll see you right at the end. Hi Anna, and welcome to Commerce Meets Law. Super excited to speak to you as one of the first conversations of the new year. So before we start any conversation, we always have an icebreaker on the podcast, which is, in your opinion, what is your superpower?
My superpower, I would say, is empathy. Not because I think it should be a superpower, but because I think it is underrated and undervalued by others.
Amazing. And I think that it's going to play a really important role in the rest of our conversation as well. Before we get to sort of talking about your current work, I want to take a couple of steps back. So can you tell us when you sort of first developed an interest in law and when you thought that it would be a path for you?
I think before I developed an interest in law, I had an interest in justice. I think it starts really early on, and I think it can start really early on in childhood. It can start as advocating for a friend in the playground, having a really strong sense of what's right and wrong. And then it's later on, as you become a teenager and you start to work out what subjects you're interested in and what your strengths are, that I think then it can develop into a real passion for law.
Definitely. And did you always know that taking the barrister path was for you, or did you kind of figure out along the way that this is the kind of route you wanted to take into the profession?
I think, like a lot of people, I explored options. I was open-minded, particularly going into my law degree. I didn't do law A-level or anything like that, but I knew that advocacy was something that I was really attracted to. So when I was at university, I explored becoming a solicitor. I looked at becoming a barrister. And it became quite clear quite early on that becoming a barrister was going to be the path that I was going to take. I enjoyed mooting and debating and all of those extracurricular activities that are quite closely aligned to taking either the barrister route or becoming a solicitor who perhaps has an interest in undertaking some of his or her own advocacy or specialising in litigation. So I think having those interests at university can often take people down the path towards becoming a barrister.
Definitely. I think that that's something you hear so often about, that love for advocacy, as well as that aspect of, being able to control your own time and kind of really building key expertise in a particular area. And I really want to talk about your practice because I think that family law is always sort of been a really interesting area for people to explore, but perhaps one that they kind of talk about or discover later down the line. So can you tell us a bit about what drew you to family law as a practice area in particular?
I think it's a really good point that it's something that people often want to explore. Certainly when I did my law degree, and I expect it's still the same, law is not a foundation subject for a qualifying law degree. So it's not something that everybody has to do. I did choose to do a module in family law because I knew that it was something I was potentially interested in. And when I did mini pupilages, when I was working towards choosing the path that I was going to take, I decided that there were probably two main areas that interested me, and those were crime and family. And that's really for the basic reason that they are about people. I knew that I wanted to spend my time working with people on cases that were important to humans. It's about really important things, family life, home life. And when I undertook those mini pupilages in those two areas, it just became really obvious, really early on, a bit like being at university and doing mooting and debating, that family law was the thing that really interested me. I think when you find the thing that you are supposed to do, it draws you in, and you absolutely know that there is a magic in there that you just need to keep chasing and keep pursuing. So once I'd done those mini pupilages, I decided that family law was going to be the thing that I really wanted to pursue. And then when I became a barrister, I did become a family law specialist. And I started out doing all areas of family law, as a lot of really junior barristers will, because you go into it and not only is there a lot to learn, so there's a lot to learn about what's going to suit you, what type of barrister you want to be, and what really excites you. But it's good practice. It's really good to do a range of things when you're starting out, because it really gives you that breadth of knowledge and experience that you can't get anyway other than by going and doing it, by doing the cases that are completely unfamiliar or feel hard or don't feel natural to begin with. Because when you're just starting out, nothing is natural. You're having to learn all of the skills, all of the knowledge. So I started out doing all areas of family law, and then it really narrowed down. By the time probably I was about 5 years cool, that was when I knew that children law was the thing that I was really, really interested in. So now I would describe myself as a children's specialist. I specialise in children law, with some other smaller areas as well, such as forced marriage, deprivation of liberty, and injunctions.
And just before we talk a little bit about your expertise, for people who are listening who perhaps have an interest in family law or maybe doing that module that you did at university and are thinking, this really excites me, I want to go into this. Can you tell us a bit about what that application process was like in order to get your pupillage at Harcourt Chambers, and what you think in hindsight made you a successful candidate?
I think it's probably quite different now to when I was doing it. So when I was at university, I did my applications in my final year. Now, it's not easy, and I won't pretend it is, because you're preparing for finals. I was writing a dissertation, but I decided that I was going to give it a go. I was ready to give it a go. I chose an inn of court. So first of all, you make a choice about which inn you're going to join, and when I applied, I went and got a copy of the pupillage handbook, which was a bit like a hard copy Argos catalogue. I really fear that nobody listening to this podcast is going to know what I mean by that. But I went to the law faculty and I got the physical directory of chambers offering pupillages. And I was really fortunate. I had a cousin who had a friend who was a barrister, and they'd gone to bar school together. And she said, "I know a family law barrister. Let me put you in touch." And I spoke to her, and she talked me through the questions I should be asking myself when I'm looking at chambers. And I think if anyone has an opportunity to do it, make the most of it. Say yes, phone the stranger, have a half-hour conversation, because it really did help focus my mind on what I should be looking at in different chambers. And that can be as straightforward as, what areas do you think you're likely to be interested in? Do you want to do divorce and children? Do you really think you might have a leaning one way or another? Because you really want to check on the profiles of the people in chambers and see what they are specialising in. And so that's what I did. I got my catalogue, I got my pupillage directory, and what I did was I folded over the corner of every single page that had a family law set in London with a pupillage award that I could live off. Things have changed there a bit now as well, but those were my criteria. Is it in London? Does it do family law? And is the pupillage award enough that I can be comfortable completing my pupillage? And once I had done that, I had a whole load of folded down corners, and I spent hours online. I looked at all of the chambers' websites multiple times. I looked at the CVs of the people at the junior end to see what life would be like if I started out in that chambers. I looked at what their hobbies were, what their interests are. Do they talk about family life? You can tell a lot from looking at chambers' websites. And now, of course, we've got social media. So you can tell a lot from looking at barristers' social media as well. What is exciting to those barristers? What do they prioritise in their work and in their life? And what would it look like for you? I didn't limit myself, though, to looking at the junior end, because you also want to see where you're going to be headed if you join a chambers. So I then started looking more and more senior up the list to see what people were doing once their career progressed. Did that look like how I imagined my career to look? Was that something I would be excited about reaching? And could that be the career that I want to take? And it became quite clear to me as I went through that process what I should be aiming for. And so what I then did was I basically narrowed it down to my top 7 chambers. I had to strike a balance because I was doing my finals, I was preparing for those, and I wanted to make sure that I was putting together quality applications. So I applied to 7 different chambers and I interviewed at 4 of them. And I knew when I did my first interview at Harcourt that for me it was a good fit. I knew from meeting the people, I knew from the questions that I was asked that I could fit in there. And I did 2 rounds of interview with Harcourt, and they made me the offer. So the feeling was mutual, is the happy end to the story. And I have been there ever since. So that was my journey into both family law and Harcourt.
I think you made such key points there. I think particularly as someone who's at university or who is looking to apply, whether that's for, training contracts or any other job or then chambers, you look at sort of websites, social media, and you don't really know what it is you're looking for because you haven't got those priorities of what's most important to you. And that may not be the same as your friend who is, also applying or anyone else at university. And like you say, the financial needs are just as important as well as what your career trajectory can look like at that particular chambers, and especially if that's the area you want to specialize in. So I think that those are some really important points that people can be thinking about when they are deciding where they want to spend their time and their energy, which is so limited in final year, and even beyond that if you're sort of balancing it alongside a job or other caring responsibilities. I think that I really want to talk about your current practice and sort of what you specialize in now. Can you tell us a little bit about what sort of issues come up most, kind of specializing in the law of children and dealing with, kind of such a sensitive area, so that people can get an idea of what kind of tasks you do and what sorts of cases you deal with?
So there's one really big division in the type of work that I do as a children's specialist. This is probably be obvious to anyone who's already done their family law module, but within children law, there's generally a huge dividing line, and that's the difference between public law children and private law children. And those are the 2 main types of cases that I do because they're the most common types of case. So private law children work is work between where there's a court case going on between 2 parents. So usually these are 2 parents who have separated and who cannot agree on the arrangements for the child. So where the child will live, whether the child lives with both of them or one of them, what time the child should spend with the other parent if they're not living with them, or other more fundamental one-off questions like where should the child go to school? Should the child receive a certain type of medical treatment? Should the child be allowed to go abroad to visit family in a place that the other parent thinks is dangerous or thinks the child won't come back from? So those are the types of cases we do in private law children. And in public law children, it's quite different. There can be an overlap. Cases can turn from one to the other. But in public law children cases, the state is involved. So you have a local authority who is the applicant. And the local authority means that if you're the barrister for the local authority, you're representing a social worker. And in public law children cases, the child is represented as well. So you are usually, if you're in a public law case, representing either the social worker, the child, or either one of the parents. Sometimes another family member, if either they're already caring for the child or they may care for the child at the end of the proceedings. The outcomes in those cases can include private arrangements, just like private children work. They might end up with a child living with one of the parents, but equally they might have a different outcome. These are the cases that are usually involving neglect, child abuse, which can be physical or can be sexual, incest. Those are usually the main types. Physical abuse can include non-accidental injury. So it can be bruising, fractures, brain injuries. And those are the more serious types of cases, along with more serious sexual abuse cases as well. So the subject matter can be very different in public law children cases. And those are probably the cases that spring to mind when people think of family law and being a children barrister, because they're the ones that you often hear about in the news. So those are the other types of cases that a children law specialist will deal with. You will often find that people who practice children law will practice other types of family law as well. Some people might do finance and private children. It's quite a common combination because people who are divorcing may need help with the arrangements for their children. But not all of those practitioners will do public children law, because public children law, where you're dealing with those really serious allegations, is quite different and it's legally aided. So it's a really different type of work. In addition to private and public children, I do injunctions, not least because sometimes it's really useful to do those when you're dealing with the arrangements for children, because you might need injunctions in those cases to keep away somebody who poses a risk to a child. I also do deprivation of liberty cases. Now, what these are cases involving really vulnerable children. They are probably the cases involving the most vulnerable children that we have in society. And what these cases are about restricting a young person's Article 5 right to liberty because it's considered that they pose a risk to themselves or to others. And so what the case is about whether there should be restrictions on their liberty and what those restrictions should be and where they should be accommodated. Usually these cases involve a young person who has really serious mental health needs, and that may be as a result of trauma or early childhood adversity. And so that's where you find lots of public children practitioners will do deprivation of liberty cases, because there's a really clear connection, and because lots of these children will be known to a local authority. So you've already got a connection between the local authority and the child. Occasionally, it's less common in my practice, these cases might involve protecting a child who is at risk of, or themselves may be perpetrating, grooming behaviours, gang-related behaviours, or county lines. So in deprivation of liberty cases, those are the main topics that we see. It's mental health, county lines, gangs, and grooming. Public law, neglect and abuse. And private law children, it's about the arrangements for the child and the disputes between two parents, where possibly both of them could adequately care for the child, but they simply can't agree. So the court has to intervene and make a decision. So it's quite a wide spectrum of issues that I see as a children's specialist doing all those areas. Some barristers will do some of those topics and not others.
That's super interesting. And I think that someone listening to this right now might be reading the news and seeing that there's been a lot in the past couple of weeks, whether that's been about grooming gangs, whether it's been about the new children's safety law that is being proposed in Parliament, or whether that is about the Sarah Sharif case and many others like that, which have been in the news. I guess from your perspective as a barrister who, like you said, deals with both the public and the private side, when you read about cases like this and look at the legislation that's coming in, how far do you think that makes a difference in terms of how that affects your approach and also how that affects the type of cases that come into your practice?
At the moment, one of the things that I think is really, really challenging in children law, and there's some coverage of it in the media, but even judges are expressing repeatedly frustration about, is lack of resources. And I think this is an issue which actually probably permeates all of these issues. You've got questions being asked in all of these areas, in the Sharif case about, well, how much time is allocated to cases in the family courts? You know, what's being offered? And so I think it's a topic that we need to be talking about because it's so relevant to all of these things. It's particularly relevant to deprivation of liberty cases. Now, one of the things that I think you'll probably see in the media quite a lot, or will have done over the past couple of years, is about lack of children's homes, lack of suitable placements. And again, that's relevant to all the decisions the court is being asked to make, because when the court makes all of these decisions, it's deciding between options for children. And the fewer good options you have, the harder it sometimes is to make good decisions about children's welfare. And what I hope we see a lot more coverage of in the next year is where resources need to be directed. Because at the moment, family law cases are being really impacted by the resources that are available and the changes that have taken place. So in terms of deprivation of liberty cases, when I first started practicing in about 2012, I was quite regularly instructed on what was called Section 25 application. Those are for secure accommodation. Now, that legislation is still in place. We could still make use of that. But at the moment, there is a real lack of secure accommodation for children. As a result, we don't use it nearly as much as we could be. And we have more cases involving the deprivation of liberty of children and unregulated foster placements and all of those issues that you see in the media. So what I hope we see a lot more of in the next year is actually going one step behind the news stories and asking about what resources are available to deal with these problems. Because dealing with the problems that you see reported in some of these cases and some of these topics might not necessarily be the problem, might be the symptom of other problems. And so I think it would be good to see some of those issues being explored a lot more in the near future. And I know that lots of judges are trying to do that in the cases. You read the judgments online and there are judges saying, we need to talk about resources. We've been banging the drum for a long time about what we need. And I hope that more people will start to take notice of that.
Absolutely. And in terms of coverage as well, I think a lot of the cases that perhaps get reported are those that make it to court and those that are sort of those high profile cases. In your own practice, how much do you sort of engage with ADR or negotiations or settlements that are done outside of court versus how much of it is actually there is no other option but to take the litigation?
I think that's a really interesting question. And actually, I think there's two things I want to say. The first one is really related to the first part of the question, which is about how big cases get reported, but perhaps other cases don't. Because I want to encourage any students who might be interested in the reporting of cases and the huge issue of transparency in the family courts, which we are all grappling with at the moment, to have a look at the Transparency Project and consider whether they are interested in doing blogging and transparency work in the family courts. You can have a look online. All of the information is there, and it might be something that students are interested in. So that's the first thing I want to say in respect of that. The second part of the question about out-of-court resolution, I think, is a really good one. We have seen over the last few years a real increase in interest from practitioners as well as clients in resolving cases outside of court. There are lots of really good reasons to do that, particularly in a family case where emotions can run really high. You're asking really, really difficult questions. And sometimes what people want is to be in control of the way that that is resolved, the timescales, the choice of who resolves it, and so on. There are a number of different types of out-of-court resolution. I think probably when you're looking at family cases, the two types of ADR that people really explore are mediation and arbitration. Both of those have their benefits. And I had an inquiry recently actually about a potential arbitration. My practice is mostly court-based, so I'm in court all the time. And I don't know how quickly that will change. I don't know if it will change. When I first joined Chambers, I wouldn't expect to have any inquiries for ADR in family cases. It just wasn't part of my practice. It may well have been part of other people's practices, particularly more senior members of Chambers who may have already been qualified as an arbitrator or a mediator. But I was never booked to cover them. Whereas this year I have had, or last year, we've just started 2025. Yeah. Last year I had an inquiry at the end of the year about arbitration. And the client was certainly interested in exploring it. And what we were looking at was choosing an arbitrator. So the client was interested in being able to choose the person who decided the really important questions about their children's upbringing, having the case decided at a place and a time of their suiting, and doing it in a more amicable way than they felt was achievable by attending a court building and building up to a big case. I think for this particular client, part of the attraction was working out all of those details with the opposing party. If actually you can get on the same page as the other person in terms of the who, what, why, where and when, how are we going to do this? I think for some parties that in and of itself is valuable because it feels like actually they are working together to try and sort it out. So having had that inquiry at the end of last year, I do wonder whether this is something that people are going to start to explore more and more over the next 12 months, particularly when we hear reported news of court backlogs and the delays and the wait people are going to have and the amount that pushes up costs. So again, I think this is a really interesting topic for people who are entering the profession to start to explore. I expect that we will see an increase in people training as mediators and training as arbitrators, but also I expect we will see an increase in barristers acting as lawyers, because when there is an arbitration, you might appoint a barrister as the arbitrator and you might have two barristers on each side arguing just as they would in court. So I expect that we will see an increase in barristers undertaking this type of work in family law, and it's something that I think should be quite exciting for people who are coming into the profession and wanting to make a difference. The more options we have for clients that are good options for resolving their difficulties, my opinion is that the better for everyone, because that's what we want to be doing the whole time. We want to be offering families the best service, the best ways we can of resolving their proceedings.
I think that particularly with family law, when the cases are so sensitive, particularly when they involve children, there's a lot of sensitive issues. There might be abuse, there might be sort of financial difficulties on both sides. I think that with court backlogs and having to wait weeks, months, even years to have that hearing, if mediation, arbitration, or other forms of ADR can play a role, and I think that that's something that is an interesting and a positive turn for the profession in the area. From your perspective, I guess that it's not always possible for cases to be dealt with in that way, particularly if, it's a really adversarial sort of scenario and both sides are just not willing to compromise. From your perspective, having had so much experience and expertise in this area, how do you balance that ability to recognize the sensitive kind of nature of the case, but also ultimately being realistic and practical about the best outcome for both sides?
It's really important to always deliver accurate and pragmatic legal advice that you have confidence in because of your experience, because of your learning, and when you're really junior, from talking to others in chambers as well and checking, am I on the right lines with this advice? And I think all lawyers, it's a really basic aim to be delivering the right legal advice. And I expect that everyone who comes into it has that right at the top of their to-do list. Right, what am I going to advise my client? What cases are relevant to this? What statutes are relevant? Have I read any judgments which give me a clue about where the outcome for this case is likely to lie? I think calling them soft skills, it does them a disservice, because actually I think people do tend to view them as soft skills. Being compassionate, being balanced, having that empathy. They're not really soft skills. They're completely essential, not just because you are going to be attuned to your client and able to provide them with a better experience because you are understanding their motivations, what's important to them. But first of all, you might be better able to guide them to the right outcome. Because if you don't understand why your client feels a certain way about something, why they feel so strongly about a particular thing, you're unlikely to be able to guide them from that position to what the court might order. Because if you don't understand why they're saying something, you might think, well, the court's never going to grant that, no matter how strongly you feel about it. But telling them that won't necessarily help. What you might need to do is explore with them why they feel that way and how that can be sorted out so that you can actually reach a different sort of compromise, or help them to understand why a judge might not agree with that answer or that position or that stance. So I think, first of all, you can actually get better outcomes. You can actually settle cases or take your client to a position that's much more likely to be successful if you have that empathy and compassion and can really listen to where they're coming from. Secondly, if you understand your client's case really, really well, you will argue it better. If you can understand why something is so important to your client, you might argue it differently. You may win or you may lose, but I think you stand a better chance of winning a point if you really understand where the client's coming from. And even if you don't win, what is really important to your client is that their case has been argued, that you've understood it fully, and that you have put their case at their highest. Because when you are advocating for someone in court, you're being their voice. You are there to say the things for them that they would want to say if they had the law degree, and if they had the confidence in court, and if they had the skills and experience to know how best to argue the case. You can't be your client's voice unless you're listening to them, and unless you are showing that compassion and that empathy that really allows them to connect with you and explain what's important to them, what their goals are, why something is particularly painful. I mean, I'm often the first person to stand up in court and say to everyone, this is really painful for my client to listen to because of this, that, and the other. Or my client is always going to find it really hard to accept X, Y, and Z because of this thing that has happened, which it means that the trust has broken down or means that it's particularly triggering. Sometimes that means that actually the outcome might change, and sometimes it doesn't. That's important, but it's not the only important thing. It's really important that your client knows that was on the table. They've said their part, because if it was them standing up and saying it, they might well just say it. So I think it's really important to do a good job to balance those things. But when you're at law school and when you're doing your degree, when you're doing the bar course, there's an element of that discussion. We talk about client skills and that sort of thing, but it's not given the same focus as learning the law, learning the rules, learning the regulations. And that's probably for good reason, because there is so much to learn when you are getting the skills that you need to become a good lawyer. But I think if we carry on that conversation once you enter into practice, I think that people will find it easier to add those skills into the work that they do. It's particularly important in family law because the conversations we're having with our clients are really difficult. There are conversations that we have where we have to say to our clients, your baby's going to be adopted. The judge is going to make the decision that your baby is going to be adopted. I can't see a different outcome, and I'm really sorry about that. And it's awful. It is awful delivering that news, and nobody wants to. But if you are compassionate about it, you can guide your client through that process in a way that is much less traumatic. So one of the ways, for example, that I do it goes a bit like this. Clients usually want to know what the judge is going to do. And if you've been representing them for a while, or if they've had really consistent legal advice, by the time you get to the final hearing and you get to that point, you've already started to prepare them. They know what you're going to say because you've done your job. So you get to the point where they need to know what to do, and you have to say to them, you've got a choice to make. You've got a choice to make today, because actually the judge is going to make the order at the end of this final hearing, and we probably can't do anything to change that outcome. What we can change is how we get there, and it is your choice. You can choose to contest it, and we can choose to say that the social worker should give evidence, and we can choose to say that you want to give evidence, and you want to be able to say to yourself at the end of this that you fought it all the way, because that's what's really important to you. Or we can make another choice, which is equally as valid, which is we stand up on day one and say, we know it's not going to happen. We know that we're not going to win this. And what we want to do is stand up today and say, we love our baby. And that's it. And that's going to be the end of it. And by giving clients those choices, you're empowering them. And that's better.
Definitely, I think that it's that difference of, being compassionate isn't always telling them what they want to hear, but actually what the reality is, and for them, and to prep them, and like you say, to support them, to know that there is still a solution, but it may not be what they want to hear, and that kind of telling them about that difference. And I think that's what will make someone who is a good advocate, but also someone who understands you and understands your situation, and isn't giving you false hope just for the sake of making you feel good in that moment, but it not ultimately resulting in the solution that you want. And I think we spoke a lot about, those difficult moments and those challenging conversations. But perhaps looking back at your career at Harcourt, what would you say have been some of the most rewarding moments, some of the moments which have made you feel like you're really doing this for a reason, and you're really making a difference?
I think particularly in family law, although I'm sure it is true for all barristers in all specialisms, the highs are so high. Those cases that you win, you feel like you are floating on air. There is nothing like it. And for me, with my practice and my focus on children law, the highs are probably the obvious ones. It doesn't happen very often that I get to be the bearer of good news, not least because quite often it's the judge delivering the decision, quite frankly, at the end of a case. So it's the judge who says what the outcome is going to be. But sometimes there are cases where your client is a parent and their child is in foster care and you are successful and you get to be the one to say to them, do you want to go and pick your children up today? And it is just the most amazing feeling in the world. There is nothing like it, and there will never be anything like it. So those are the highlights, I should probably think, for any public law children practitioner.
Absolutely. I think that, like you say, that there might be lows, but the highs really do make up for the fact that, it reminds you why it is you're doing what you're doing. And at the start, we talked a little bit about sort of your journey and why you wanted to go into family law and kind of into the bar as a whole. One of the other things that I really wanted to talk about and how I came across you was particularly through your posts on LinkedIn. I always found them really engaging, and it always gave me a lot of insight into a profession and particularly a practice area that I didn't know a lot about. Can you talk a little bit about sort of this growth in social media and barristers sort of building a personal brand? Do you think that there have been enough of them doing it, or do you think that this is something that the profession is yet to make a change in and more people should be doing what you're doing?
I absolutely do think more people should be doing it. I think it's not surprising that they don't. And I'm going to show my age again. But when I first qualified, there were really strict restrictions on what barristers could do and could not do in terms of marketing. As a result, the only marketing that I had as a junior barrister was a plain business card. It had the Chambers logo on it and my name and barrister and the contact details. That was it. And I had a website profile. Marketing was so restricted, and that has changed. And I've actually written an article about it. If anyone wants to read it, it's in the Barrister magazine this month. So the January 2025 issue, you can read all about it and look up all of the footnotes for the regulations that have changed. But the basic summary is this: we were really restricted before, and it's now been recognised that actually it's not realistic, or nor is it the right way for us to move forward. And there is a need for barristers to be able to market themselves, including on social media. Now, that has changed within my career so far, and that probably gives an indication as to why more barristers are not marketing themselves. Lots of barristers who trained either when I did or before had a fear of social media and marketing drilled into them because it was so restricted. It is really hard to shake that fear off. The fear that nobody's going to want to read what you're going to write, that it's not in keeping with the profession because previously it wasn't, that it's going to stay on the internet forever. All of the things that we are told about internet safety as students at bar school. We are told, remember, everyone's going to look at you. Every time you interview somewhere, everyone's going to look at everything you've ever written online, and you have to be really careful of it. And that's probably not bad advice. We probably should all bear that in mind. But I think sometimes it is therefore easier not to do it because, particularly at the family bar, it's really busy. Children law, it's really busy. Public law, children law, really busy. We have so much work the whole time coming in that it can just be easy to think, oh, you know what, I'll just let the clerks fill my diary and I'll do my cases really well. And if I do my job really well, I'll advance in my career and that will be enough. But I think there is a lot that social media has to offer that we will be missing out on if we don't embrace it and start to work out how to make the most of it and how to connect with different audiences. And I think there are a number of different ways that social media is helpful. And one of them is engaging with students. So I did a post on LinkedIn a little while ago where it was a 5-minute post. And it's always the way, isn't it, with the ones that get the most attention. 5-minute. And I had straightened my collarette. I was going to a ceremony in the Royal Courts of Justice, and I'd use my hair straighteners to do my collarette, which I always do because it's the best way, because you just straighten them and they come out beautifully. And so I'd taken a photo of it, and the post was really about social mobility. And it was about saying, look, sometimes we have to say to people, I straighten my collar out with my hair straighteners. I don't get the ironing board out. It's too much effort. I use my hair straighteners because actually students can see that and picture themselves doing it. And so I think it's a really good way to connect with students and give people the confidence to ask themselves, could I go and do that job? Could I belong there? And that's great for diversity. It's also great for recruitment because after I did that post, I think I had about 200 people follow me, and I had to scroll through and it looked like loads of them were students. And I thought, well, this is great because as a Chambers, we want the best students to apply to us. We want the best students to say, Harcourt Chambers, I know about them. My values align with theirs. I can see myself fitting in with members at Chambers. I can see myself bringing something to the table. Our values align. I'm really interested in social mobility or the rights of children or welfare of children or forced marriage or deprivation of liberty and the way those two things balance. And members of Chambers are talking about that. And I want to be part of that conversation when they're sitting in Chambers and talking about their cases. I want to be there and I want to be part of it and I'd be a good fit. We want all of that because we want to recruit people who are passionate about these things. And so I think it's really great for recruitment because everyone can see it. Everyone can see what we're talking about and what we care about. So I think it's really great for that. Good recruitment is great for Chambers, is great for clients, is great for everyone. So we should use it for that. Second of all, I think it's great for connecting with clients and solicitors. And the reason for this is when I first joined Chambers, we didn't have social media, we didn't have remote hearings, and solicitors would phone the clerks and they would say, I've got this case. Who's available? Who would you recommend? Who does that type of work? And there would be this dynamic conversation about it. Quite often now what we see, particularly post-COVID, because we see the emails coming in, is solicitors will email maybe 6 chambers, top 6 chambers, sometimes 3 chambers, or sometimes just us, with a case. And they need it covering. And they're just asking basic questions. Who have you got available? What year of call? What's their fee? Often. And so all the clerks will send back the information. It's not necessarily in the same way that it used to be, that dynamic conversation with a clerk. Oh, who does that work? Do they do lots of private children? Do they, is this something they've done loads of? Do they have a particular experience in working with clients who are autistic? Because I've got a really vulnerable client and I absolutely need the right match for them. Doesn't necessarily happen anymore. So how do we get that information to solicitors? How do we tell them what we are good at, to put it bluntly? And I think social media is a really great way of getting that information across. And actually, I have had a solicitor phone me up and say, I want you to represent this client because of something that you spoke about on social media that absolutely struck a chord. And it's because you're right at the front of their mind because you have just posted about forced marriage. If you've just done a post about forced marriage and a solicitor gets a client in and thinks, I need someone I like to talk me through this, or I'm thinking about issuing a certain application, or I need somebody who this client is going to build a rapport with. If they've just seen your post, or if they've been reminded that you're there because they've seen your photo on social media about something else, they might think, that's an obvious great fit. I'm going to phone Anna's Clarks and see if she's available. And that might not happen without social media. I also think there is an argument that this is going to increase and that actually lay clients as well as solicitors are going to be looking on LinkedIn when they make their choices. Sometimes a solicitor will phone up and want a variety of options for the client, and we'll go back to the client and say, these are the people that are available at Harcourt. Have a look and see who you think might be a good fit for your case. Sometimes what they will do is they might look at practice areas. They might say, okay, well, I've got this particular aspect to my case. It might be divorce and it might be pensions. So they might say, okay, I want somebody who talks on their CV, on their profile about pensions, and they'll go and they'll click and they'll have a look. Or sometimes it might be, I want somebody who's ranked in Legal 500. I want someone who's ranked in Chambers and Partners. I want to be, that's the sort of level that I think my case is pitched at. And I want to have somebody with those qualifications or with those reviews. And so they might look at it that way. All of that information can be on social media. So if you have a LinkedIn page where you say, I'm a leading junior in Legal 500, or this is a review that I've had from a client, or these are areas that I'm interested in, clients are probably going to read it, and that might mean that they decide that you are the right fit for their case, and they might then go back to their solicitor and say, yeah, I've looked at the list of names that you've sent me, and yeah, I saw that this person posted about pensions or whatever it might be. I want to go with them. And it's a good thing, because clients need to know that they are choosing somebody who is well suited to their case. These cases are so important. They want somebody with the expertise, with the experience, or with the personality that they're seeking. They might be seeking somebody who is articulate or funny, or that they can really relate to. And there's no point in pretending that they are not going to go on social media and have a look. Is there? So my view is that we should be embracing it, learning about it, absolutely, balancing the risks, balancing the advantages, because like everything in life, there are things that we have to weigh up really carefully. We have to have really healthy boundaries, both as an individual and collectively. We have to decide what those are going to be. And these are new issues that we're all talking about. We've not done this before. We haven't done the social media thing. And we are still working it out. Working out how regularly to post, how to champion each other's posts, what the value is of a repost or a comment, and all of this sort of thing, to make sure that we are reaching our audiences and connecting with all the right people. And so I hope that these are all conversations that we will continue to have. I expect there's going to be more training in social media use for lawyers. I expect there's going to be more lawyer-to-lawyer training on it and conversation about it. I expect it'll be more often a topic in conferences, more often a topic in articles like the one that I've just written. And now is the time to jump on it, is my view, and to start to at least think about it, work out whether it's something that you're interested in. By all means, not everyone has to do it. There's always going to be an element of personal choice. And a bit like practice areas and diary management, everyone has to think about what feels right for them. But I think it's important that we're having the conversation about it, and that people are making conscious decisions rather than letting it go by and thinking, well, I'm really busy, I don't need to worry about it, and missing opportunities that there are at the moment, because there are opportunities on social media to develop practices and to connect with other people.
Definitely. And like you say, the legal profession's always sometimes been a bit infamous to change, or been a bit risk averse. And I think that perhaps has been the longest with technology, social media, all those kind of things. But I think that as we embrace, whether it's AI, whether it's social media, whether it's other forms of, technological revolution, I think that it's something that not just people entering the profession, but also those already in the profession definitely do need to think about. And I guess as a final question, you've given us so much of your time today on that topic of social media. If you could give someone who wants to build a brand, whether they are, kind of at the start of their profession or a couple of years in, what would be your 3 top tips on how they can create a sort of powerful social media presence, which is good for recruitment of their own chambers, but also to attract clients and build their own practice?
Focus on yourself first. Don't do it for the purpose of getting a job or achieving a particular business development aim or making a particular move. By all means, if you want to, go and do it. But my advice would be, instead of worrying about all of those things, focus on what you're offering first. Focus on what is important to you, because you can't have a personal brand without having the person first. So work out what's really important to you. Work out what you're interested in, what you want to talk to people about. After that, the personal brand, it comes so easily because you've already done all of the work. And quite honestly, those questions are much more interesting to think about anyway. Think about what's really important to you, and it will build from there. If the thing that's really important to you is, for example, social mobility, and you start to think about, why is it important to me? What do I want to contribute? What can I offer this space? The rest will flow naturally from that. I think it is really important, before you start, to think about what your boundaries are going to be. Not just because of how addictive social media can be and all of the metrics and all of that stuff that comes with it, but think about how you're going to keep yourself safe. How are you going to keep yourself safe online, where you might receive negative feedback, where you might find yourself being invited to join in conversations that you don't want to be part of, or exposed to things that you don't want to see, or where you might end up posting things that you later regret. So I always think it's really important before you start, think about what your boundaries are going to be. And they don't have to be the same as anyone else's boundaries. By all means, talk to people and find out what they are, what they're thinking. What do you do? What don't you do? What will you share? What won't you share? Even down to things like basic personal information. Are you going to share what town you live in? Are you going to share what your children's names are? Are you going to share photos of your children? All of these questions, think about it before you start, rather than starting without a plan and then thinking, actually, I probably wouldn't have done that if I thought about it.
Yeah.
So safety from both a literal safety sense and also from a well-being sense. How are you going to keep yourself safe? Those are my top two. You asked for three, didn't you? I think those are the most important things, definitely. And also, probably the last one is don't feel under any pressure. You see a lot on social media about how often you should post and all of those sorts of things. And by all means, we should be having the conversation about it. We should be having the conversation about what's effective marketing, what's a good way of connecting with people. But actually, social media has its advantages. That shouldn't be enough to put yourself under a pressure that actually is unenjoyable or unrealistic. It's never going to be worth that, because social media is only one part of the picture. And if it feels like it's unmanageable or that there is too much pressure, don't just sit there and suffer. Talk to someone about it. If you are a student, talk to other people that you're close to or your peers and find out what their experience is. If you're in chambers or in a, if you're a solicitor in an office and you're feeling like there's a pressure to do it in a certain way, have a conversation about it. What other types of marketing is going on? Can someone take a break from social media? Can someone pass some responsibilities on to others? And I think that's really important. And I speak as somebody who's had periods of time off on parental leave, a long time of part-time working. And I haven't always, during those times, been able to make a contribution to marketing in other ways. I haven't been able to do conferences when I've been at home with a young baby, or when I've needed to get back for the school run at 3:00 because there's no one else to collect my child that day. I can't always then go and speak at a conference, but actually sometimes during those times, it might suit me to do a social media post and say, actually, this is what I'm bringing to the table at the moment. At the moment, I can really concentrate on social media. It really suits me. It fits in with my life. I can't contribute to conferences, or I can't do an evening at the moment because I've got an elderly relative and I need to go, during the evening to go and do that. Or actually, I'm not well at the moment and I can't travel long distances. We have to have the same conversations about social media. There can't be the expectation of, well, you can just do it whenever, you've got a laptop. That's a great advantage of it. But also we should be able to say to people, actually, this isn't working for me at the moment. I'm feeling the pressure to write and actually I've got nothing to contribute and it's getting all out of hand and I'm feeling like I have to post because I have to post 3 times a week. Nobody should feel that way. Put your hand up and say, actually, this isn't working right now. I need a break, or I want to try something different. I want to go out for a coffee with someone. I want to take a week off and not post and not even open LinkedIn. I can guarantee you when I'm on holiday, I do not open LinkedIn because I am on holiday and I fully intend for that to continue. And so I think having those principles and feeling able to stand up and say, actually, this is too much, it's not for me right now, is really important. So I don't think anyone should feel under any pressure to join in with something that at the moment isn't working for them.
I think that, like you say, that there seems to be that pressure now that everyone is on social media and so everyone needs to be that. But there should always be the health warning of you need to do what's right for you at the moment. And just because you can't do it now doesn't mean you can never do it. It just means that, this phase of your life, perhaps that is not the priority or the most important thing. And I think with that, Anna, thank you so much for coming on the podcast today and giving us your time, learning about your work and your journey, and also everything that you've done with social media. It was so interesting, and I think will be really inspiring for everyone listening. So I really, really appreciate you coming on the podcast today.
Well, thank you for having me, and thank you for the questions. It's got me thinking about some other things as well. Thank you so much.
And on that note, thank you so much for listening to this episode, and a massive shout out to Anna for taking the time to come on Commerce Meets Law. I had such a good time recording this episode, and I enjoy recording every episode that I have because I just think that, every guest that comes on this podcast is so fascinating. But there was just so attractive and enigmatic about Anna's presence, and I just felt like I could talk to her forever. So thank you so much for giving me such a platform, for listening every single week so that I can have such amazing guests on this podcast. If you enjoyed this episode, and I really, really hope that you enjoyed it as much as I enjoyed recording it, please do let me know by emailing commercemeetslaw@gmail.com or with a DM on Instagram at Commerce Meets Law. And you can now also reach out to us through the website, which has the same name, commercemeetslaw.com. And it also has links to the podcast, our YouTube channel, and all of our social media platforms as well. So it's a good one-stop shop for you to look up all sorts of Commerce Meets Law content. For now, take care, goodbye, and I'll see you very soon on the next episode.